colleagues in Launceston. Tonight, this is part of our regional outreach program. In April, the team attended Burnie, and in the end of this month and the 1st of June, we'll be going to Queenstown. And we consider it very important to engage with the community and make sure that we aren't seen Hobart scenes. It's very important to get about and speak to the community and raise awareness of what we're here to do and listen to your feedback on any issues that we may have. Tonight you'll be addressed by the Integrity Commission's Chief Commissioner, Mr Murray Kellum AO. I would also like to acknowledge in the audience Ms Liz Gillan, who is a board member of the Integrity Commission, who's travelled up especially for the program thank you Liz. And there are a number of Integrity Commission staff here this evening that will be able to help with any queries if Murray can't field all the questions. I'm very pleased and honoured to introduce our Chief Commissioner, the Honourable Murray Kellum AO. As Queen's Counsel, Murray has practiced in all states and territories of Australia. He was appointed Queen's Counsel in Tasmania in 1993 and appointed to the Supreme Court of Victoria in 1998. Murray retired as a judge of the Court of Appeal of the Supreme Court of Victoria in June 2009. During his career, he has conducted ethics training for judges and magistrates throughout the last decade. In fact, he led a 2-hour workshop for Tasmanian magistrates in Burnie in February. Murray has worked with legal systems in South Africa, Fiji, Papua New Guinea, Cambodia, Nepal, Bangladesh and elsewhere. He's a great humanitarian and very committed to helping young people and the less fortunate than ourselves. He was appointed Chief Commissioner of the Integrity Commission in August 2010. Before I ask Murray to step up, I'd also like to recognise Carolyn Langley from the Commonwealth Ombudsman's Office and Matthew from Papua New Guinea, who's looking at international programs here in Australia and Tasmania, and who's a particular interest in community engagement and regional outreach. Without further ado, I'd like to call on Murray.
Thank you for coming. I think it's very important that we try and have as many public meetings as possible. I think it gives people an opportunity to see what we do and what we can't do. The intention here is to basically provide community information about the Commission, about its functions, its jurisdiction, its capacity and what we would see as the future for it. In 2009, your Parliament here chose to create an Integrity Commission, which is in fact quite different than any other similar body in Australia. It commenced operation 7 months ago. The first major difference between this organisation and similar organisations in other states is that it's not a crime commission. It would seem that the legislature didn't think that a crime commission was appropriate for Tasmania, and I expect that it did not see the same sort of problems that you have in Victoria, New South Wales, Queensland, Western Australia in that regard, and that seems to be the case. But that's one significant difference between this body and other bodies, and it means that some of the sort of coercive powers that are available to crime commissions are not available to this body, and perhaps properly so. Secondly, it's called an Integrity Commission.
Wouldn't that be better to have had that even if you didn't use it?
Well, look, I'll have a discussion about that later. We don't have those powers. We don't have the coercive powers. I'm not sure, and I'll come back to this later. I'm not sure we do need some of those powers. I mean, a crime commission can haul people in.
Your second sentence was in and what we can't do.
Yeah, what we can't do.
Well, that's
where
I think you should start.
Well, perhaps
like everybody's.
I'll come back to that. I'll come back to that at the end. There are some matters I want to deal with first. First, it is called an Integrity Commission, and it's not an anti-corruption commission. Other bodies are called that. This is quite specifically not. The intention of Parliament was not to have corruption as a word in the Act. And in fact, if you search the legislation, you'll find it's not there, and I think deliberately so. His Excellency the Governor, Peter Underwood, said as follows in relation to that matter. With respect to the Commission's investigative function, it may be noted that corruption, unlike criminality, is a word of uncertain meaning. Its content and meaning varies according to the perceptions of the speaker and the listener. It's an emotive word, and I venture to suggest that the work of the Commission will be greatly assisted if people, particularly those who are able to speak with the protection of privilege, that is Parliament, take time and thought before making an allegation of corruption. Past experience has taught us that such allegations, often made without proper basis, are seized upon by the media and by the process of widespread repetition gain unjustified veracity and cause public unrest. Now, I wasn't around when this bill, as it then was drafted, but it seems to me that it's a deliberate omission, if you like. Nevertheless, and I'll come to answer your question in more detail later, the Commission does have power to investigate conduct which is a breach of the Code of Ethics, which is dishonest and which is improper. And one form of alleged misconduct which features in the complaints that the Commission has received from other parts of Tasmania, but this part of Tasmania, the north, is that of a perception of conflict of interest. And I want to speak briefly about that particular possible form of misconduct. As I say, it features quite prominently in a number of the complaints that we have seen. What is a conflict of interest? A conflict of interest is a clear conflict between the public duty of a public official and some private interest. It doesn't have to be pecuniary. It can be a personal interest in a better result that's private rather than public. That is, there's a collision between the public duties of such a person and some private interest. More specifically, conflicts of interest can be actual. I think probably we don't need to talk about that. Actual is pretty clear. Usually somebody has a conflict of interest or they haven't, and that would be clearly unethical. Perceived conflict, however, is a more difficult thing to deal with. And it exists where a reasonable observer might consider that private interests do interfere with the public duty. That can be so whether it's the case or not. And public servants have to take care about perceptions of conflict of interest as well. And then potential conflicts of interest are very important to the management. That is, identifying what is potentially a conflict and what is not is very important to the management of these processes. So I just want to talk a little bit about this before I move on to the powers and the jurisdiction of the Commission. First of all, it seems to me that it's likely that in small communities, such as in northern Tasmania, a conflict of interest is almost impossible to avoid. And I've worked in other quite small communities. I've worked with Matthew from the Ombudsman Office in PNG. I've worked in PNG. It's a relatively small community. I recently worked in Mulgrave, which has almost the same population as Tasmania. And in those sort of communities, you're more likely to have a conflict of interest for obvious reasons. There's nothing unusual or necessarily wrong in there being a conflict of interest. For instance, in small communities, it may be an inherent conflict in the appointment of any staff. It may be that small councils, if they're employing people, will employ people who are known to those running the council. There's nothing wrong with that, and it is to a degree to be expected. However, it's the management of that circumstance which is really in issue. And it's about reality and it's about good governance. Conflict of interest, however, can lead to misconduct and it can lead to serious misconduct. Real or perceived conflict of interest can lead to impaired community trust, and I think that from my reading of what's happened in Tasmania in recent years, that's been certainly part of the issue which led to the passing of this legislation. It can be handled, however, in a way which is consistent with the public good. It requires proper management, and I think probably to summarise where you start with management of conflict of interest, sunlight is the best antiseptic. Full disclosure is the first step. A proper process to encourage and to manage full disclosure is necessary, and that needs to be in councils, it needs to be in state government, it needs to be in anyone dealing with the public interest. It needs to be part of their agenda. That does need to be associated with appropriate confidentiality in some cases, but a consistent approach throughout the whole of the public sector is necessary. It's the role of the Integrity Commission to encourage and to assist the public sector to manage conflict of interest issues. Will we ever be free of conflict of interest issues? I suspect not. Is there ever a situation where there's no public officer misconduct? I suspect not, no matter what processes you introduce. I'll come back to some community expectations about that. Nevertheless, the Integrity Commission has as one of its important objects the education of public sector, be it local government, be it state government, police and other business entities operated by the state as places where models of avoidance of conflict of interest, models of avoidance of misconduct can be implemented. And that's a very important part of the role which is set out in the legislation, which of course, as I think probably most people in this room know, followed from recommendations of the Joint Select Committee. However, the Commission does not have any statutory power to penalise, to fine, to imprison, to sack. The reasons for that were set out in the Joint Select Committee's committee report. We have the power, however, to report to Parliament at any time. That's probably a fairly powerful tool, but we don't have power to directly deal with people. We do have power to recommend to an appropriate body that they should be dealing with this particular issue. If they ignore us, we then have the power to report to Parliament. In terms of those findings, those recommendations, we do have an obligation to accord those that are complained about and those who make complaints procedural fairness and natural justice. One of the issues that I think has arisen, and I've seen some public complaint about it, and I've seen some letters of complaint about it, is whether the confidentiality under which we operate is necessary. I think the answer is in varying degrees, yes. I think there are some things we deal with where it's not, but in others it certainly is. The first reason for that is procedural fairness. It's not appropriate for the respondent to a complaint to be in effect hanged by the media before the thing's investigated or looked at. However, and the experience elsewhere has been, I think in Western Australia, people have committed suicide after a matter that was the subject of investigation became public and before it had been properly investigated. Thirdly, and I think really importantly, the investigative process in which we might engage in certain cases is not assisted by a public debate on it. Indeed, one notice that we have power under the Act to give requires the person being brought in to be interviewed not to discuss it with anyone else. And you can see, obviously, if you're investigating a serious matter, you don't want to come into people that are engaged in misconduct deciding what answers they'll give. So confidentiality is important from that regard. It's also important, some of the people who make complaints to us publicly announce them, others don't, and some complainants make anonymous complaints. And under the Act we will examine their anonymous complaint if we consider it appropriate. The Act is intended to give whistleblowers some protection. I'm not sure the Act does so sufficiently at the moment, but that's a different matter in terms of amendment. But that's the intention of it. So there are very good reasons why we engage in confidentiality, but I can accept that there are concerns. We don't want a secret commission, and I'm very conscious of that. Our purpose, our statutory purpose, is to improve the standards of conduct, the standards of propriety, the standards of ethics in public authorities, including in state and local government, and through that process to improve the community understanding and confidence in our public authorities.